Welcome everyone to Division 4 of the Colorado Court of Appeals. My name is Bob Hawthorne. I'll be presiding over the proceedings this afternoon. To my right is Judge Ted Tao, and to my left is Judge Henry Nieto. We will constitute the division that will be making the decision and writing an opinion on those cases that are scheduled for this afternoon. On our 1:30 docket, we have two cases, People versus Weber. Weber or Weber? Weber. I see counsel are set up and ready to go on that case. I'll ask in advance, are counsel involved in a state of Rabin or Rabin here already? Good, okay, thank you. Just a few things before we get started. The time is self-monitoring. I think I recognize both of you as experienced appellate counsel, so you're probably familiar with our timing system already, but that's self-monitoring, and you may reserve some time as appellant for rebuttal if you wish to do so. One of the other things I'll mention is that we are now live streaming our oral arguments as they occur, so you should consider that during your presentation or during your arguments this afternoon. Have counsel had a chance to look at our policies and procedures protocol handout, and do you have any questions about any of those? All right, thank you. And for those in the gallery, I'll remind you to check your phone or your any other device that you might have that might go off during the proceedings, and make sure they're turned off so that they won't disturb the counsel in their arguments or the court in considering those arguments. With that, if you have any other questions, or if you don't have any other questions, rather, we're ready to proceed on People versus Weber, 2016 CA 908.
Thank you, Your Honor. Good afternoon. My name is Amy Trenery, attorney registration number 46148, and I'm appearing as alternate defense counsel for Everett Weber. I'd like to start with the substitution of counsel issue and then transition into the jury instruction issue. And my intention in joining those two issues together is to highlight for the court the relationship between the two, and particularly the relationship between the harm analysis in the substitution of counsel issue and both the error analysis and the harm analysis in the instructional issue. So under the Arguello case, a complete breakdown of communication supplies good cause for substitution of counsel. I think it's pretty clear that that was what was going on here. On his first day of trial, Mr. Weber and his counsel showed up, and she immediately informed the court that Mr. Weber was not willing to talk with her during his trial. If that doesn't constitute a complete breakdown, I'm not sure what does.
Well, was she unwilling to talk to him?
She said that she was trying to talk to him and he wasn't responding. So she could talk with him. She didn't necessarily have any assurances that he was listening or taking in any of the information. More importantly, because he wasn't talking to her, he wasn't available to answer any of her questions about the evidence that might be coming in, ways that she could have countered that, witnesses they might have called, and potentially whether he was going to testify in the case.
But if he's the one choosing to shut down communication, if that were enough to create an Arguello level of breakdown in communication, wouldn't that allow a defendant to completely manipulate the system and just get as many new lawyers as he wants because he stops talking to the one he has? In
a vacuum, if there was only one factor, yes, but that's only one of the four Bergerud factors. So here, the four factors, the court in the answer brief, the district court in the answer brief, really focused nearly exclusively on the fourth factor, which is the extent to which the defendant substantially and unreasonably contributed to the conflict. And so I think his choice not to speak to his counsel at that point goes to that factor, but there are three other factors. And so whether there was a total lack of communication is a separate factor. Who was the cause of that, goes to a different area. I really don't think that and then the court's inquiry into the circumstances, sort of, the three are very much related to one another. Here, I just don't think that the court inquired deeply enough in order to understand what the grounds for this conflict was. Mr. Weber's counsel brought up the idea that Mr. Weber said that she was treating him unfairly, not advocating on his behalf. Mr. Weber himself said that his lawyer wasn't representing him properly and failed to investigate critical evidence. And then when the judge started inquiring, they really were just talking about evidence where Mr. Weber had some disagreements with his counsel, and they talked about two specific pieces of evidence, a 911 call and then a video that a bystander had taken. But that doesn't get to the other issues that were brought up, the failure to investigate. Those were pieces of evidence that were investigated. In fact, both of them ended up coming in at trial through the prosecution. Being treated unfairly and not advocating, there really just wasn't any inquiry into those aspects. The inquiry focused just on the evidentiary issues, which caused the court to conclude that the disagreements were a matter of strategy and that those strategy decisions belonged to counsel. I think the failure to investigate is possibly the most troubling because you can't use strategy if you haven't investigated particular evidence.
What was the investigation that he alleged should have been undertaken?
Well, we don't have a record of that, unfortunately, because the trial judge didn't ask. And so I think that weighs heavily against the second favor.
He didn't tell the trial judge?
He didn't volunteer the information. I'll give him that, but he also wasn't asked. So there really wasn't a very thorough record made on this. In addition, after the judge made his initial ruling and basically said, I think this is strategy related, you're going to have the same problem no matter who your lawyer is, essentially laying all of the blame on Mr. Weber, even though he was trying to say, I have another lawyer in a different case and I don't have this issue with him. I think he was panicking, going to trial, feeling like he was going in with a lawyer who wasn't prepared and he didn't feel confident that she was going to represent him properly. So, you know, this other lawyer, when he asked during trial, he was refused. And then it sort of stands in contrast to what happened when they showed up for sentencing. Between the jury verdicts and the sentencing, Mr. Weber had filed some pro se motions alleging ineffective assistance, again trying to get this lawyer off of his case, which I think is somewhat telling. And then at sentencing, he was asking for the exact same relief for the exact same grounds. And this time, the court granted it with even less inquiry. So I think that there's some lack of principled decision-making here. And really, if we had a better record of the precise reasons why Mr. Weber and his counsel weren't getting along at the time, this court would be in a lot better position to be able to review this at this point.
Counsel, wasn't this, in fact, the third motion to replace counsel in this particular case?
So the first two motions went to the same lawyer, the same public defender, who eventually was substituted off. And
But 3 times he indicated he couldn't get along with his lawyer.
two with the first time. The first time was unsuccessful, and then that lawyer was removed, and then once with the second lawyer.
Each time, a communication problem with his lawyer. Isn't that a support for the trial judge to say a decision in this case that it's going to happen over and over if he lets this lawyer off?
For that, I would point the court to the Roca case, and that is 872 P. 2nd at page 1288. And that's a case where there was a succession of lawyers. There were 3 in that case, not just 2 like here. And the court did comment that the second time around, even though it was the defendant who was refusing to cooperate with his counsel, that refusal had still gotten them to the place where there was a total breakdown in communication. So I think.
Can we say there's a total breakdown here where the breakdown in communication happens only on the morning of trial?
I don't think that that's the case.
Breakdown?
The record doesn't say that. Actually, counsel said that they had a continuing conflict and that their communication had not been good.
But
And that's
not
on
a
page
breakdown.
12 and 13.
But not a breakdown.
You
It's
know,
not good, they've had conflict. That's not the same thing as saying there's a total breakdown.
I don't think anyone said one way or another how long the lack of communication had been going, whether it had just started the morning of trial, whether the lawyer had even tried to meet with him to prepare for trial or prepare him to make the decision of whether he was going to testify.
But all the record shows is that the breakdown, the total breakdown happened on the morning of trial. There's nothing in the record to suggest there was a total breakdown in communication prior to that, is there?
They didn't make a record of when the complete breakdown had started. I'm not sure whether, like I said, whether she had visited him in jail to try to prepare for the trial. They just didn't make a record of it. So again, it highlights the insufficiency of the record, which I think is the Bergerud factor, that one of the three factors that weighs in Mr. Weber's favor. I'd like to move on just to transition to the instructional issue so that I can talk about the relationship between the two. So I think that on all three of these issues, the harm analysis comes down to the answer brief's arguments that the evidence was overwhelming in this case. And I'd like to talk about the reasons why I disagree with that. So the first thing, looking to the instructional issue, I think this is a fairly clear error under the Geisendorfer case. Quite some time ago, this court looked at a nearly identical error where the word imminent was left out of the menacing jury instruction and included that was erroneous. The question then turns to the harm in this particular case. The answer brief rests fairly heavily on the idea that defense counsel didn't contest imminence in the closing arguments or through cross-examination, didn't put on any witnesses, so it couldn't have been that way. So I think we need to look, first, the nature of the error affects the harm on all of the errors in this case, and that's because by leaving out the word imminent, the jury instruction for menacing lowered the burden of proof for the prosecution. That's one less thing that the prosecution had to prove, was that the fear of bodily injury was imminent bodily injury, not imminent fear. There's no definition of imminent specific to this statute, but there is helpful case law, which I discussed in pages 47 and 48 of the opening brief. The Yaklich, Brandyberry, and Robertson cases, as well as Mosijemba, that's my best guess. They all assert this idea that for something to be imminent, it has to be on the verge of happening, immediate. It's about to happen right now. And here, in the context of the evidence, the way that it came out at trial, I do think that there were grounds for the jury to find that the fear of bodily injury was the injury that was feared was not necessarily imminent. First of all, the weapon that Mr. Weber was holding was a hammer. And in contrast, in Geisendorfer, where the court found the instructional error harmless, that case involved a gun, and the defendant was pointing the gun at the victims during the menacing innocent. So there really was not much of a question about whether the defendant could have inflicted imminent bodily harm. There's a gun pointed at the person. All it takes is to pull the trigger. Let
me interrupt you there. Within the context of the circumstances here, was there, in your position, was there a distance at which the imminent serious bodily injury could have been perceived by the victims or not? How far away did the defendant have to be from the victims for the serious bodily injury to be not imminent?
Sure. I'm not sure that I can pinpoint an exact distance, but I can point you to the things in the record that show that distance might have been evidenced. Mr. Safi testified that, at least at a certain point, he wasn't afraid that Mr. Weber would hurt her because he was, quote, at a distance, and that's on the February 17th transcript at page 273. Mr. Safi also testified that he was the one, not Mr. Weber, he was the one controlling the situation the entire time. When the hammer came out, a lot of the threats were made before the hammer even came out of the Winnebago. When it did come out, the Safis locked themselves behind the office door. That shows that, subjectively at least, there was some fear, but Mr. Safi also came out to confront Mr. Weber. Mr. Weber says he threw the telephone at him. Mr. Safi says Mr. Weber headbutted him, although the jury acquitted Mr. Weber of the assault count.
Counsel, your focus is on Mr. Safi's actions. Isn't the focus in menacing on the state of mind of the defendant, not the state of mind of the victim in terms of whether fear was actually felt? So if the focus is on Mr. Weber's actions and his knowledge, his knowingly creating the fear of imminent danger or imminent bodily injury. Is the analysis of imminence different when it's what he wants them or what he knows they will experience as opposed to what they actually experience?
I think his knowledge of whether they would be afraid or not is nevertheless affected by the context of where people are standing, how much protection they have, whether they feel safe enough to come in or out. He, mostly was just holding the hammer down by his side. The one time that the evidence shows that he did hold it up, he was threatening to damage cars and not people. So again, there is some evidence in the record that I believe that the jury could have used in order to find that the bodily injury that the Safis may have feared was not necessarily imminent under these circumstances. And unless the court has other questions, I'd like to reserve my time. Thank you.
Good afternoon. May it please the court. My name is Marixa Frias. My attorney registration number is 38746, and I'm here today on behalf of the people of the state of Colorado. Simply, Your Honors, the menacing convictions here should be affirmed. The trial court's determination that substitute counsel was not warranted is fully supported by the record and was not an abuse of discretion. The admission of evidence relating to the victim's fear of defendant at the time of the incident was directly relevant to proving the crime of felony menacing and also relevant to the victim's credibility and demeanor. And finally, the jury instruction issue, any error in the trial court's failure to include the word imminent in the elemental felony menacing instruction was not plain error. Again, imminence was not contested at trial, and there was overwhelming evidence of defendant's guilt.
How can it not be plain error when the statute actually uses the word imminent and the word imminent is left out of the jury instruction? I mean, that would be pretty plain to the judge, wouldn't it? If the word imminent is in the statute, that it should be included in the jury instruction?
Your Honor, in preparing for this argument and in rereading my brief, I think that the better practice, yes, would have been to include the word imminent in the jury instruction. Certainly, that is part of, it's included in the statutory language. But I think that the Geisendorfer, that's 991 P. 2nd 308, is directly on point here. That court, another division of this court, looked at the very same issue, which was the omission of the word imminent from the jury instruction. And there, it concluded that it was not, that it was harmless error because the evidence of imminence was not contested and the evidence of the defendant's guilt was overwhelming.
But isn't there a significant difference in the imminence of harm from someone holding a gun and someone holding a tool?
I think, Your Honor, that whether something is a deadly weapon, it can be an animate object, it can be an inanimate object. Your fist, case law has held that a fist could be a deadly weapon. A foot could be a deadly weapon.
So under that analysis, would you suggest that if I were to shake my fist, say, at the bailiff in the back of the room, would it be reasonable for someone to say that that's a fear of imminent serious bodily injury when I'm this far away because my fist might be a deadly weapon?
I think in the context, I don't think, no, there's not any, my understanding is that deadly weapon has to be, for felony menacing, there has to be a threat of assaultive conduct.
Okay, so I make a verbal threat and I shake a hammer at somebody sitting in the back of the room, and I'm, what is that, 20, 25 yards away. is that sufficient to demonstrate someone might have a fear of imminent serious bodily injury, as opposed to if I point a gun from 25 yards away?
I think the focus needs to be on your intent to place that person in fear and not on the victim and whether they're aware. I think there's case law that says that for felony menacing, that it doesn't even matter if the victim doesn't hear a threat or doesn't even see a deadly weapon. So I think, again, the focus needs to be on your conduct.
And focusing on my conduct, and I only stated that I made verbal threats because that demonstrates, at least inferentially, my state of mind. Focusing, however, on the difference between waving a hammer from 25 yards away and pointing a gun from 25 yards away, is it at least distinguishable in your analysis of the case that the likelihood of my knowledge that I was causing a fear of imminent serious bodily injury might be different with a hammer than it is with a gun?
I think both of those instruments could be capable of producing serious bodily injury, and that's the inquiry.
So imminence is irrelevant according to your argument?
No, Your Honor, I disagree that imminence is relevant, but I think that and there's no case law defining imminence in this context. So I guess I would agree that there is a distinction between a gun and a fist.
And if I may just clarify, based on your kind of opening comment, are you abandoning the argument that imminence is not an element of the charge?
I am saying that, yes, it should have been included in the instruction. And here, because there was no objection, the standard of reversal for that error would be plain error, and there was no plain error here because imminence was not contested. And I'd like to just go back to your questions because we have to look at the facts of this case. In the facts of this case, the deadly weapon was a 14-inch ball-peen hammer. And the victims were they were out on the parking lot, and the defendant went back into his Winnebago after he had been yelling threats that he's going to burn the dealership down, and they got on his bad side. He went and retrieved this hammer and came out of his Winnebago holding it in his hand, yelling, "I'm going to burn down the dealership, I'm going to kill you." So I think that under the circumstances of this case, the imminence is inherently implied here with the defendant holding that 14-inch hammer and yelling threats of death to the victims. And so for that reason, I don't think that there was plain error for failing to include that word in the instruction. Does that answer your question?
What would be the distinction in that scenario between felony menacing and public display of a deadly weapon in an alarming fashion, which is disorderly conduct?
Your Honor, I haven't researched that issue, but I think it goes back to the intent and the focus on the actor, the person holding or using an instrument with the intent to place a specific person in fear.
It's not with the intent, it's just knowledge. They're both
Yes, what I mean, they're
both
aware
knowing
that their
crimes.
conduct is going to is practically certain to place that person in fear of imminent serious bodily injury.
They're both knowing crimes. One of them uses from the deadly weapon and the alarming fashion in which it is used results in a disorderly conduct misdemeanor. One of them results in a much more significant felony and much more significant potential sentence. If you are able to say, if one is able to say that the deadly weapon inherently makes the imminence there, then isn't there a significant due process problem and equal protection problem where the same exact conduct can satisfy both crimes with significantly different penalties, with no rational way of distinguishing between them?
Your Honor, I vaguely remember, I don't have the case names at the top of my head, but I do think that there's case law that addresses the distinction between those two crimes and how that there is no due process or equal protection violation.
You're right, but the reason they're different is because of the imminence factor. And if you're going to essentially minimize imminence to a automatic inference anytime there's a deadly weapon involved, don't you eliminate that distinction and then create problems under that existing case law?
It's not my intention to suggest that I am eliminating imminence. And I was trying to clarify that it's error here, but it's not plain error. I can't think of a scenario where a person holding a deadly weapon and yelling at someone very close to him, "I'm going to kill you," that there's not that's not imminent.
Under the facts in this case where there's the difference in the proximity of the people at different times throughout this whole event, isn't that a jury question then, whether there is a danger of imminent serious bodily injury? I mean, it's not a given. This is not an incident where somebody stands in front of someone and waves a hammer. This guy's all over the lot. He's on the porch. He's out by his vehicle. There's a lot of evidence. Isn't imminence a pretty important part of that equation?
I'm not denying that imminence is not part of the equation. I'm saying
that wasn't my suggestion, but I'm saying the evidence here raises a significant issue, or does the evidence here raise a significant issue as to whether or not there was imminent fear of bodily injury, or fear of imminent bodily injury?
Respectfully, Your Honor, no. I don't think that there's a significant question here when you look at the totality of the evidence that came in. After the defendant retrieved the hammer from his Winnebago and yelled at the victims holding the hammer in his hand, the victims, in fear, retreated to their office and locked themselves in the office, and defendant approached the office, approached the window, raised the hammer, and Ms. Safi testified that she feared he was going to break the window with the hammer. So I think looking at everything in context, I don't think that there's a significant question that that defendant was aware that he was putting them in fear of imminent serious bodily injury. Does that answer your question?
It's a good response.
Thank you. If there aren't any more questions on that issue, I just want to say very briefly on the substitution of counsel issue. Again, the trial court made more than an adequate inquiry. He heard from defendant and from Ms. Garshin. There was certainly a history here of defendant complaining about his counsel and conflicts that they had. The allegations he made here were addressed in 2 previous Bergerud hearings regarding introduction of the evidence that he wanted. Ultimately, the complaints were strategy related, and so given his history and the multiple hearings, I think the record shows that the trial court's determination that substitute counsel wasn't warranted was not an abuse of discretion. And if there isn't anything further, the people respectfully request that the judgment of conviction be affirmed.
Thank you, counsel. And counsel, you have about 1 minute and 49 seconds left to rebut.
Thank you, Your Honor. Judge Tao, I'd like to pick back up on your example of shaking the hammer at the bailiff. It raises a good question. Is that sufficient to put the bailiff in fear of imminent serious bodily injury? But what if you weren't even shaking the hammer? What if you're just holding it down by your side, which is what I believe the record shows that Mr. Weber was doing the entire time when anyone was outside of the office. When Mr. Safi came out of the office with his phone, Mr. Weber didn't go after him with the hammer. Mr. Safi said he headbutted him instead, and the jury even acquitted him of that. So the example that I can give you is in Geisendorfer, where the defense didn't mention imminence in closing arguments, but the prosecutor did, and pointed to specific evidence showing, quote, that the victims were in fear of dying right there on the spot. So that is imminence. A gun pointed at you, you know you could die any second. When I look at the difference between menacing and disorderly conduct, it comes down to what the result is. So not intentionally, but knowingly placing someone in fear of bodily injury versus just doing something in a manner that is calculated to alarm others. So I really do think that the imminence supplies the rational distinction between those two crimes. And here, without imminence in the jury instruction, it lowered the prosecutor's burden of proof. And I think that that's the foundation of the harm in this error, on top of the evidence that gave the jury the ability to find that the prosecution hadn't proven imminence beyond a reasonable doubt. And I would ask the court to reverse Mr. Weber's convictions. Thank you.
Thank you, counsel. Thank you both for your arguments this afternoon. 2018 CA 160. Counsel are set up. Do you have any questions about our procedures or protocols here in the Court of Appeals? All right. Thank you. And with that, we're ready to proceed on the State of Rabun. Counsel, you may proceed.
May it please the court, my name is Liesl Pettis, bar number 44791, and I am here on behalf of the appellant. While there are various issues in front of the court today, I would like to spend a bulk of the discussion about the personal representative's rights to the attorney-client files of the decedent. This issue is very important for two reasons. First, the estate is still open in our case, but second, there really needs to be some clear direction for probate attorneys across the state of Colorado right now. This really, in many ways, is a matter of first impression. There is no statute, rule, case law that is specifically on point with this issue. Now, there are some statutes that we would like the court to consider, as I think it gives the court good direction to determine that a personal representative is, in fact, entitled to those documents. First would be the Colorado Revised Statute 15-12-709 and then also 711. In 15-12-709, that gives the personal representative the rights to possess the property of the decedent. 711 then goes on to state that the personal representative has the same power over the title of the property as the decedent or the absolute owner themselves. Now, this, in essence, is saying that a personal representative steps into the shoes of the decedent. And with them stepping into the shoes, they also then have the right to the attorney-client files of that decedent. And this makes sense because a personal representative not only has to collect all the assets of the decedent, pay off the debts, and then distribute the rest, but they also can sue and be sued on behalf of the estate. And they also have the fiduciary duty to actually protect the estate and its assets.
Along with the right to the files, the decedent's files held by an attorney, does the personal representative obtain the right to waive the attorney-client privilege? Does it go that far?
We assert that yes, both. That not only does the personal representative have the right to the attorney-client files, but they also then become the privilege holder for any of those communications. And I think that the case Wessup versus Everson is actually a very good example of this. In that case, it was a personal injury case. A daughter had actually sued her father and mother, and after the parents had actually committed suicide, the personal representative and the estate were substituted in as defendant. Now, the case itself really hones in on whether or not the daughter, who is not the personal representative, had a right to the files of the decedent. The court said that she did not, and we absolutely agree with that. The privilege remains after somebody passes away, and a third party does not have privy to those documents. However, the personal representative, who is now party to the case, it's my assertion that it would be absurd for them not to have the privity to the documents that could actually help them uphold their fiduciary duty to defend the estate, even though they're party. So for them to not have access to that would make it nearly impossible for them to actually defend the estate in a lawsuit such as Wessup versus Everson.
So is, based on your description, is there any limitation? In other words, does there have to be some showing or at least some reasonable inference that the attorney files might contain information relevant to the administration of the estate, or is it a blanket, it's property, it's mine?
So I would assert that it's pretty blanket, and I think that there's some good case law, as well as the Colorado Bar Association Opinion 132 that would direct the court to that conclusion. However, in this case, the court has said that the personal representative has zero access to any of the files. And so I would certainly at least ask this court to consider, if you do not agree with the full 100% of the client attorney files to go to the personal representative, at the very least, any of the documents that have to do with the estate itself, closing the estate, but also any potential litigation concerning the estate should be privy to the personal representative. And at the very least, a court should be doing an in-camera review to determine what documents would go to the estate. But it is our assertion that all those documents, because the personal representative steps into the shoes of the decedent, then become the property of the personal representative themselves, and the personal representative becomes the privilege holder at that time.
I'm also interested in the limitations, if any, of your analysis or your position. Would the personal representative under your position be able to require the decedent's attorney to sit down with him or her and disclose everything the decedent's attorney knows about the business of the decedent, or any other privileged information that the decedent's attorney may have privy to?
I assert that the attorney would have to reveal the communications and the documents, as would a former client that went to a new attorney, what they would have to disclose at that time to a new attorney. So really, any communication that the decedent was entitled to, if he had terminated that representation if he was alive, that personal representative now also has that same right to those documents and communications.
Documents, and so just to be clear, not only what's in the files, but what's in the attorney's memory about things that were said to him.
Right.
Is that
And I think-
property?
Well, I think that's becoming a little conflated, and I apologize. Generally, if one client is going to new representation, the communications themselves do not need to be memorialized and sent over. However, we also now have this layer of the testamentary issues, and that is an exception within case law that we already know exists. And so if the communications have to do with something testamentary in nature, as was true here with the deed of trust, as well as the promissory note, both which were to be executed upon the death of Mr. Raven, that, yes, I think the communications would also go over. Past that is the documents themselves. So I think there's kind of two pieces to that. I think that the Colorado Bar Association, while obviously not binding on this court, I think it's very persuasive as to what the general practice is and what is kind of considered as what is allowed for the personal representative at this point in time. And that opinion repeatedly states that the personal representative does, in fact, have a right to the documents. In fact, it says specifically the personal representative who holds the rights to the client information. But it also talks about how the personal representative has the right to waive the privilege just as the decedent would. And I think that's a really important piece. Now, the opinion itself is not just directed on that issue. In fact, it's really talking about third parties again and an attorney's ethical obligations concerning any requests from third parties when it comes to these testamentary documents. But it seems to have no issue or even just blanketly states that a personal representative does in fact have this right to waive the privilege. And so if they have the right to waive the privilege in that circumstance, then certainly they have the right to waive the privilege when they themselves are the ones trying to gain access to those documents. I think this also can be seen in People versus Palamo, which, again, I do understand it's distinguishable, but as I stated before, I do think this is really a matter of first impression. And so we need to look to other cases to try and glean where the court should go with the issue within the probate case. And that one has to do with the medical privilege, but as we know, the privilege for both medical as well as attorney-client is couched under 1390-107. And so I would argue that really that case should give some direction to the court that the personal representative does have the right to waive the privilege for the attorney-client documents.
Is there any limitation on that right?
No, I don't believe there is any limitation on that right for waiver. Once again, I would assert to the court if there is some sort of disagreement that it should be merely just the testamentary documents or documents that would be pursuant to litigation, that it would then at the very least require a court to do an in-camera review. But we believe that a personal representative does have that right for a complete waiver of privilege. And
Let me be clear. I'm not asking you if there's a limitation on what privilege is held. I'm asking if there's a limitation on what a personal representative can do in terms of the scope of waiver. In other words, is it
Okay.
at least limited by the fiduciary obligation to the estate?
yes, absolutely. I think that that is very clear within law that the personal representative has that fiduciary duty to do what's ever best for the estate, which would be for the decedent. So yes, absolutely, there's a limitation there. I think it's also important to remember that it is the decedent themselves prior to the death that actually appoints the personal representative. They can appoint whomever they want. They are not required to appoint their spouse. They're not required to appoint anybody within their family. They can appoint who they want. But further within the law, it allows for a decedent within their will to actually accept personal property or information to not go to the personal representative. So if there was something to actually be secretive or something that that individual did not want the personal representative to know, they have the right to exclude that information or property from going to the personal representative. So this is not a carte blanche item either, that when somebody dies, anything goes. That person has complete control over who they're appointing and then what in fact goes to the personal representative. And then the fiduciary duty, I do believe, would then hold that personal representative responsible. Unless the court has any other questions, I'd like to hit 2 more points before reserving my time for rebuttal.
I do want to ask one thing about that.
Sure.
If in fact the design is to hold the PR to the fiduciary obligation, how would that ever be protected? Let's say the PR gets information and decides this is so scandalous and so scurrilous and maybe I can sell my story to or my decedent's story to the Inquirer or whatever it may be, I can profit off of this. Who's going to stop him or her? If all it is this fiduciary obligation, who's going to bring him or her into court and say, no, 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 you can't do that?
You know, I think that would go to the same rules and effects of any fiduciary duty held by that personal representative. So if the personal representative was to be stealing money from the estate, I think it really is being held to the same standards. So I don't think there would be any difference between their other fiduciary duties that they held. Just briefly, I do want to just touch on the rogue pleading by Mr. Frierish. I think that that one is a very straightforward issue, that he did not have standing to file a pleading, was essentially filing it on behalf of the claimants in that case, which is just unheard of. I don't see any legal standing for him to do that, and we would be asking the court as well to reverse that decision. And I'd like to reserve the rest of my time.
Would it have been proper, since it's, my understanding is what he addressed in that reply was, although nominally aimed at the petition for a claim, it factually addressed the allegations about his involvement and really was more of a surreply in the subpoena issue than in the petition issue?
I think that's still completely inappropriate for somebody to be filing a reply pleading in a claim that has nothing to do with them personally.
But if he's the subpoenaed party, he has standing to brief that issue, correct?
He was subpoenaed specifically in the subpoena ducis tecum, which took place a month or so earlier. As far as the claim itself, he was not a party to that. If we had a third party always able to assert a reply or response at any point in time to, correct the record, we could have 10, 15, 20 people starting to put in their own response and reply. So I think it's a slippery slope for the court to take that direction.
Maybe, but is it an abuse of discretion for them not to sanction it?
I think it was abuse of discretion because I think it's very clear he had zero standing to file it. I don't think that there is any grounds, and we haven't seen any case law statute rules that say he had any grounds to file that reply.
Again, even if I accept that, is it necessary that every bad act has to be sanctioned? Does a court not have some discretion to just say, you shouldn't have done it, but I'm going to ignore it?
I don't think the court even said that much. The court should have stricken it because it was a rogue pleading. The second piece is whether or not it should have been sanctioned. So there's two pieces there, the motion to strike as well as the motion to sanction. And I think it would have been acceptable to sanction it because it was an inappropriate pleading.
Acceptable maybe, but necessary. Is it acceptable not to sanction it?
I think it would have been necessary because, like I said, this is a slippery slope. If the court allows an attorney to do it in this case, why can't they do it in every case? I think
in terms of
required.
Striking it, since the issue was ultimately, the petition was ultimately deemed moot by the settlement, why would you bother striking a pleading that you're not going to resolve the pleaded issues anyway?
So it hadn't been at that point in time. The settlement happened shortly after. But it was, to me, this is a slippery slope. If the court says an attorney can correct the record anytime he wants, whether or not he's party or representing a party, now we can have anybody, whoever they want, to now be essentially replying and responding to whatever motion they want. I think it's necessary in order to sanction them to essentially tell all attorneys and all third parties that this is unacceptable behavior and there's no reason that it should be happening. And I actually have 7 seconds left, so.
Good afternoon. My name is Nancy Cohen, and with me is my colleague, Nicole Black. Part of the argument I think that the estate makes in this case just shows why this appeal is moot and that the Court of Appeals should not be ruling on these issues. And that is the problem with the appeal to begin with. Really what the estate wants is it wants an advisory opinion to say in all circumstances the personal representative has the attorney-client privilege and can waive anything and can get any information from a former attorney regardless of whether or not any of the information that personal representative wants has anything to do with the estate. In this particular case, Mr. Frierish has represented the decedent for a significant period of time. He had approximately 43 or 44 boxes of files that went over a period of time. The documents that relate, and he did not draft the will. So asking about a testamentary exception for the will does not apply. He did draft the promissory note. He said that the decedent's ex-wife, Sunu, I think is her name, was present, and he provided his notes to the estate on that promissory note. And as he explained to the court that he had no independent recollection, he gave the notes. He doesn't remember why he drafted the promissory notes. He knows that he notarized them. So the documents and the other documents that were the quitclaim deeds, those went into evidence.
Ms. Cohen, on the mootness issue, if I may, the subpoena asked for all of the files, correct?
Correct, and then it was limited by Mr. Fisher in an email.
In the sense of, okay, I'll take at least this, right?
I would not say, okay, I'll take just this. What it says is, what I'm interested in is whatever you have on the promissory note, which was provided before the hearing occurred, and then the parties stipulated, and when I say the parties, meaning Mr. Freerich and the estate, stipulated to the promissory notes going into evidence as well, or the promissory note, as well as the quitclaim deed.
But was the subpoena ever withdrawn?
The subpoena was not withdrawn, but
So isn't there still an outstanding claim for the remaining files? And therefore, this isn't moot?
No, there is not an outstanding claim because there was a motion to quash the subpoena. And in essence, the motion to quash was granted when the trial court, after hearing the statements from Mr. Freerich, looking at what was provided, understanding the arguments, saying, okay, the promissory note with the notes has been provided. You have not, estate, provided any case law that really supports your position. You're entitled to other things. And that is why the court found that the continuation to insist upon getting the 43 or 44 boxes of files was really groundless under these circumstances, and that is why the probate court entered an order for fees.
I understand that. But my point being, the argument is that decision was error. If in fact it was error and it goes back, then they get all the files. So there is still a pending controversy, is there not?
Well, I wouldn't say that they get all the files. I guess the question is, if that was error because the probate court abused its discretion, which I will argue the court did not, but understanding your hypothetical here, then what it would do, I think, is go back, or what we would ask is that the court remand and make a determination whether or not the estate is entitled to the other files for the purpose of continuing to finish the estate, the probate matter.
And again, this inquiry is limited to addressing your mootness argument. But,
Right.
But what I'm hearing is, yes, there is potentially, if we find some error somewhere along the spectrum, there's still something going on with the claim to these files. So is this really moot?
It is moot in the sense that, for the second argument, is that the estate has now settled with the claimants, the two claimants who said that they were entitled to information. So it is moot because they don't need the documents that they're seeking, the 43 or 44 boxes of files. They don't need them in order to determine how to settle the estate. That has already been done. And in fact, the court said that both in its December 18th, 2017 and its December 27th, 2017 orders that, well, I guess you don't need the files because you have already settled and therefore the issue, there is no controversy and the issue is moot. So
how does the estate know that it's time to settle this estate? This is a large estate. 43 files could involve a lot of things. Claims against the estate, claims the estate may have. There's all kinds of things possibly in those files. And what I hear you saying is that Mr. Friedrich gets to decide what he will release and what he doesn't release. And the estate, who owns the asset or owes the liability, has no right to discover those things. Is that what you're saying?
No, that is not what I'm saying. What I'm saying is that there were claims that were before in this estate. And I don't think you can look at it as generally that this is what could happen. I think you have to look at what the facts are of this particular case. And what the facts are of this particular case, while the estate was open, is that there were two claims, from the ex-wife and from the daughter. And what they needed to know, which had to do with quitclaim deeds and had to do with promissory notes, those files were provided, and information was provided by Mr. Freerich at the hearing. And so they didn't need the rest in this case.
Who gets to decide what they need?
Well, I think ultimately the court is the one who should be the one to decide, and the court
Before us.
and the court did decide that. The court looked at it, the court looked at the arguments, the court looked at the case law that was cited by both parties and the ethics opinions that were cited, and said, no, this is not what, the information is sent, in essence, has already been provided for what you need. So the court has made that decision.
Ms. Cohen, if I may state a hypothetical, and I don't mean by any stretch to be suggesting that this is what happened, and I do not mean by any stretch to be casting aspersions on Mr. Freerich, but let's say Attorney Smith has represented a decedent for many years. A PR takes the estate because the individual has died, and hidden in those files of Attorney Smith is very clear indication that Attorney Smith has engaged in malpractice and the estate has a claim against him. How does anyone ever find that out if the PR doesn't get access to all those files?
Well, if there is some reason to think that there may be a malpractice, and assuming that it would all be timely, and it isn't from 25 years ago, in which presumably the decedent already knew whether there was malpractice because the decedent has continued to use this particular lawyer, then they bring it up to the probate court and let the probate court make a determination.
How would he know about it? How would anybody know to bring it up to the probate court unless they got the files to look through and discover it?
Well, I guess that's a question of, it would have to be brought up at some point if the PR thinks that there is somehow.
Well, maybe the PR doesn't think this. The PR doesn't know. The only person that knows this, and under Judge Tao's hypothetical, is the attorney involved and the decedent. And the decedent obviously is not around to bring it up. But the PR, how is anybody ever going to know that there might be that claim against the attorney without having access to the files?
Well, I think you have to have, though, a basis. I still think you have to have a basis. There has to be some information based upon what the assets are of the estate that you may think that there is some sort of malpractice or some other issue, then you bring it up to the court. But to say, and this goes really to the third point, is you should be able to get any information that may be in the files, because I'm curious, as the PR who happens to be the spouse, who had no idea that her husband had given a promissory note to his ex-wife, that she should be able to look at everything to make a determination when the decedent may not, and clearly in this case, didn't want her to know that he had given a promissory note to his ex-wife.
Perhaps that's the case. Perhaps the decedent did not want his ex-wife or his present wife to know that. However, isn't that just indicative of the fact that there might be things out there that the decedent didn't tell the current wife, who's now the PR of the estate, didn't tell her about those? And isn't that indicative of the fact that there might be things affecting the estate in the attorney's file that the PR doesn't know about right now, unless the PR can gather that information and take a look at it?
I think then what you have is under your scenario, Judge, is you're saying that the decedent's desires to want to keep confidential information and information that he provided to his attorney in doing certain business deals and doing whatever it may be, private from his PR, who is the current spouse, that will always give way to having the PR be able to get the information regardless of what the situations are.
Unless he states in his will that the PR doesn't get those files.
Well, then you're asking all the probate lawyers to say to the decedent, make sure you state in the will that, I've been your lawyer for 25 years, and I don't want you to get these files. I mean, that's...
Why is that difficult?
Well, it's a difference in what you've done. That doesn't relate to the estate. It relates to cases that are closed. It relates to other kinds of work.
But again, the
Well, then
PR,
you're changing
it's
what-
the PR who needs that information. And why would the lawyer, who's not the PR, get to make that decision as to what the PR needs or doesn't need?
Well-
And one other point, while I'm taking up all your time, the PR's duty is not just to defend claims, it's also to collect and marshal all the assets. Well, that information could be in those files too. With 25 different cases, there may be a claim against someone else, not the lawyer. There may be an unresolved claim against someone else that needs to be pursued. There's all kinds of things could be in there, and the PR needs to know that in order to marshal the assets and defend claims. I'm not understanding why you think that's wrong.
Well, in this case, the PR didn't need to know that. There isn't an allegation that...
I'm sorry to interrupt you, but you keep saying the PR didn't need to know that. And it appears to me that the Colorado statutes say, yes, the PR needs to know everything about the estate. As Judge Nieto just said, the PR needs to marshal all the assets, know what all the obligations are to be able to administer the estate.
But the files are not assets. That's, I guess, the question. There is a distinction between, are the files assets? I understand what the statutes say about the PR has a duty to marshal assets. And in this case, they had questions about particular, I realize their claims. There wasn't, nothing had come up in this estate to say, I'm not able to marshal the assets. I'm not able to defend creditors' claims other than the two creditors' claims that came up, the two claimants.
You say
So
they're
there
not
isn't-
assets. Are they property?
I would argue they are not property. Files are not, they're papers, but they are not, I would argue, are not property.
Do you have any legal support for that?
Well, if you look at Rule 116 of the Rules of Professional Conduct, they distinguish between papers and property. And I have not looked much beyond to say that, but when they say you have to turn things over, they're talking about papers or property. So there has to be a distinction between property, meaning either real property or tangible property. And I would argue that this is not tangible property, these are papers. And so I disagree with Judge Nieto about, well, you know, there might be something in those files, something that occurred from 25 years ago or 30 years ago or 10 years ago. Presumably, that would any assets that there would be in either the will or a trust, if there's a trust, or already the property has already been given away and wouldn't be part of the probate estate to begin with. I do think you have to look at the,
I see
have
that
one
your
more second.
your time is up.
Thank you.
Thank you. Counsel, you have actually 5 seconds for rebuttal.
I just wanted to note briefly that the settlement agreement actually excluded the dispute with Mr. Frierish itself, so it was actually excluded within the settlement agreement.
Thank you. And the court thanks both counsel. Thank you very much for your excellent arguments, and those arguments are going to be helpful to the court in reaching a decision and rendering an opinion or issuing an opinion. So the matter stands submitted to the court, and a written opinion will be issued in due course. Thank you very much. Counsel are excused. Thank you. You're aware that the time is self-monitoring, both of you, I'm sure, and that you can reserve time, counsel, for rebuttal if you wish to do so. And with that, we are ready to proceed in People versus Grunholt. Is that right? Grunloh, I'm sorry, I don't have my glasses. I should put these on. Grunloh. That's 2015 CA 649. You may proceed, counsel.
Thank you. Good afternoon. My name is Megan Morris, bar number 43963, and I represent Mr. Grunloh. I know my time today is limited, but I would like to try to touch on both of the issues raised in my brief, so we'll see how that goes. As to the first issue, Mr. Grunloh twice told interrogators that he did not want to speak to anyone about anything. The interrogators failed to stop the interrogation. The question here is what effect that conduct has on Mr. Grunloh's subsequent statements and whether they are admissible. To answer that, this court has to go through three issues. First, was there an unambiguous invocation of the right to remain silent? Second, did police fail to scrupulously honor that invocation? And third, does that invalidate Mr. Grunloh's later Miranda waiver? The answer to all three of those questions is yes. First is to the unambiguous invocation. The question there is whether a reasonable police officer would have understood Mr. Grunloh's words to mean that he was asserting his right to cut off questioning. What Mr. Grunloh said here was twice in response to a police officer specifically asking him whether he wanted to talk to her, that he didn't want to say anything about anything. That was the first statement, and then he kind of paused for a couple of seconds before talking about what day it was. The conversation, they talked a little bit longer, maybe another 30 seconds to a minute. The officer again asked if he wanted to talk to her about the potential offenses here. Mr. Grunloh said, "I don't want to talk to anybody about anything, to be honest." The officer understood this sentence. She repeated it back to him. She said, "You don't want to talk to anyone about anything?" Mr. Grunlow said no. And instead of immediately cutting off the interrogation, the officer asked him, "Why is that?" This transitions into the failure to scrupulously honor the invocation of the right to remain silent.
Well, before you go there,
Sure.
let's take a look at the question of whether or not this one was an unambiguous statement about not wanting to talk. Do you have to take into account any other contextual material around those statements? I think, it seems to me, yes, if you read the first statement, "I don't want to say anything about anything," if you just take that in isolation, that might seem to be unambiguous. Or the other statement that he made, which was, "I don't want to talk to anybody about anything, to be honest." If you take that in isolation, it might be unambiguous. But there are some statements around that. Before the first one, he says, "I don't know. See, like I said, I don't know enough about the house." And he's talking about the house, and he doesn't know about things, and really, I don't want to say anything to anybody. So does that provide any ambiguity or not?
I think the court does have to consider the full context, but no, I don't think that those preceding statements create any ambiguity, both because of the clear language of the statements themselves, that they're very broad, "I don't want to say anything about anything," but also that, saying that he doesn't know anything about the house, or preceding the second statement, "I don't know enough about RJ, the alleged victim," that doesn't undermine the clarity of those statements, which very broadly say, "I don't want to talk to anybody about anything, to be honest." And so I think certainly at the very least by that second statement, where the police officer is repeating that statement back to him and he says no, that at the very least that second statement is an unambiguous invocation of the right to counsel.
Wasn't a part of his statement also, I don't have it underlined now, but it seems like there was part of his statement that he was concerned about having some retribution if he said anything.
Yes.
From the other folks that were involved in the activities in the house. Does that throw in any ambiguity to his statement about, does it mean I don't want to talk to you? Or does it mean I don't want to say anything about what was happening there because I'm afraid there may be retribution?
So a couple of things. I think there's one statement about a vendetta, and that only occurs after those two what I think are unambiguous invocations of the right to counsel. And under Smith v. Illinois, the court can't consider statements that occur after to undermine the clarity of those invocations. And I'm not remembering if there's anything like that that occurs before. But even if it does, I don't think that context does anything to undermine. It's simply a reason why he doesn't want to say anything about anything, but it doesn't undermine the breadth of those statements, which clearly inform the officer that he doesn't want to talk to her at all.
So what impact, if any, does it have, again, taking the first, what you phrase as the invocation, in the full context, they're talking about the context of why he's there, and they want to know what happened Sunday, and he says, Sunday, where was I Sunday? I was home all day Sunday. Investigator says, okay, so this is something you're willing to talk to me about? He says, I don't know of anybody getting injured. So clearly he's not yet saying he doesn't want to talk.
Right.
Okay, so do you want to talk for a while? I don't know. See, like I said, I don't know anything about the house. I don't want to say anything about anything. And he immediately continues and says, Sunday. Today's Wednesday, right? So he's still talking about it, even though he just said this kind of toss-off comment, right?
That's correct. And
now, the next time he says exactly the same thing, isn't the fact that the first time he said it and kept talking, doesn't that inform a reasonable officer's viewpoint of this phrase that he then invokes again? Last time he said it, he just kept talking. So doesn't she need to clarify?
Well, I think to the extent that that's the case, she does clarify, you don't want to talk to anybody about anything, and he says no.
That's just repeating his statement. Is that really clarifying his statement? Doesn't she then need to find out what he means by that?
Well, I'm not sure what else she could get him to say at that point. To me, that seems fairly clear. And when she's saying, I believe the state characterizes that question, why is that, as clarification. But to me, that's not clarification. She's not asking what he means by that, but rather why he doesn't want to talk to her. And I think Benia Barraza is probative there, because they're in the second, I believe, of the 3 interrogations. an officer asked almost exactly the same question. And what Benia Barraza said about that was that that was interrogation, that it was, there the detective asked, okay, is there a reason why, in response to the suspect's refusal to speak. Both the majority and the dissent agreed that this was interrogation in violation of the right to remain silent. And the majority said this question about why Benia Barraza did not wish to talk to him is a clear case of interrogation after the suspect had invoked his right to remain silent. And then a little bit later, a natural reason for a suspect not to want to talk to an officer is that the suspect does not want to share damaging information. So I think rather than being a clarification, this is just interrogation that's attempting to elicit damaging or incriminating information. Does that answer the court's question on that?
Thank you.
To go, to talk a little bit more about this failure to scrupulously honor that invocation. The officer's obligation at that point was to just cease the interrogation, if not during that first statement, which I agree was more sort of within the flow of the conversation, although I do think there was a pause directly after he said that for a couple of seconds before he kind of jumps back in. But certainly by that second statement where she repeats it back to him and he says no, that at that point the officer's obligation was to immediately cut off the interrogation. And instead here, what the officer does is ask why Mr. Grunlow doesn't want to talk to her, and then talks about the fact that the police have a warrant, that they're searching his house, and that they want to give him an opportunity to talk about the death that happened there. So this is sort of directly contrary to Mosley, where the police did in fact scrupulously honor an invocation of the right to remain silent. There, an officer immediately ceased interrogation and did not try either to resume questioning or in any way to persuade Mosley to reconsider his position. And to me, that's exactly what the officer is doing here. She's attempting to get him to reconsider his decision not to speak to her by saying, we think it's suspicious that you're not going to talk to us, and that we're not intending to honor your right to remain silent. Instead, I'm going to keep pushing you to talk, even though you've told me that you don't want to talk. Again, I want to go back to Benia Barraza on that point. The fact that those questions, as the court said in Benia Barraza, immediately followed the invocation of the right to remain silent provided an unmistakable signal that the police did not intend to honor that right. That despite him saying, I want to cut off questioning, I don't want to talk to anyone about anything, that they're going to keep questioning him, and in fact didn't cut off questioning until he invoked his right to remain, or his right to have counsel.
But in Benia Barraza, isn't it true that there wasn't the continued talking? There wasn't a way to characterize his very clear no. Do you want to talk to me? No. There wasn't Sunday. What is this, Wednesday? So there wasn't that continuation, correct?
There wasn't that, but I would say what happens in Benia Barraza in the first interrogation is that he says, no, I don't want to talk, and then the officer continues to ask him questions, and he does continue to respond. And so that, again here, the fact that Mr. Grunlow continues to engage with the officer doesn't undermine the clarity of his statement that he doesn't want to speak with her. And so I think that's the crux of that issue here, is that the clarity of that statement is not undermined by the context, and that when the officer at the very least clarifies with him or repeats that statement back to him and he says, no, I don't want to talk to you, at that point it's her obligation to stop the interrogation. Moving to the last part of this issue, the question here, ultimate question, is what effect, if this is an unambiguous invocation and the police fail to scrupulously honor it, what effect that has on Mr. Grunlow's Miranda waiver a couple minutes later. And the sequence there, again, is that he invokes his right to counsel. The officers do leave the room at that point, finally, after he's attempted to cut off the interrogation a few times. But they tell him simply, we'll be back. They don't make a definitive end to it. After a minute where he's had the opportunity to reflect about the fact that police are going to hold this invocation of the right to remain silent against him, that they're thinking that it's suspicious, and that they're not going to honor that invocation, he knocks on the door and asks them to return. He then signs a Miranda waiver and immediately, within like 2 minutes, gives this full statement about what happened, that he shot the alleged victim, and gives his explanation of why that happened in an attempt to exculpate himself. This makes perfect sense in light of what the police did here, which is saying to him, we're at your house, we have a warrant, and we think that we're holding the fact that you've invoked the right to remain silent against you, that we think that's suspicious. And so his response is to talk to them and attempt to exculpate himself. Here, I think because of the police misconduct in response, or their failure to scrupulously honor his invocation of the right to remain silent, that ultimate Miranda waiver is not a knowing and intelligent waiver of the right to remain silent. That the police conduct there influences Mr. Grunlow's decision to waive, and that therefore that Miranda waiver is invalid. I'd like to touch just briefly on the second issue, if I could, if the court has no further questions on the first issue, before reserving the remainder of my time. On that issue, my argument is that the abuse of a corpse statute is unconstitutionally vague. And I think the main dispute between the Attorney General and I on this is whether the language in Johnson applies, and in particular, whether a statute needs to be vague in all of its applications before a court can find it unconstitutionally vague. And so I just wanted to say briefly that I think it's important, even though a few divisions of this court have rejected the language from Johnson, I think this court is not free to do that Johnson is not limited to its facts. Instead, the court is specifically rejecting the dissent's position that a statute is void for vagueness only if it is vague in all its applications, and that instead the court just has to look at the text of the statute itself and think about whether it gives fair notice of the conduct that it punishes or is so standardless that it invites arbitrary enforcement.
Wasn't that issue waived by not raising it as a Rule 12 defense?
I disagree. I don't think that it was, and I would argue that this court should follow Hinojos Mendoza and Fuentes Espinoza, which simply review constitutional challenges de novo, even though they were not raised in the trial court, both as a matter of judicial efficiency and just as a matter of fundamental fairness, that if a person is convicted under an unconstitutional statute, that conviction should not be allowed to stand. And I'd like to reserve the remainder of my time.
You may.
May it please the court? Elizabeth Ford Milani, registration number 48843 for the people. This court should affirm for two reasons. First, defendant did not unambiguously and unequivocally invoke his right to silence. And second, the abuse of a corpse statute is not unconstitutionally vague. Beginning with the invocation, the standard is whether a reasonable police officer under the circumstances would understand the conduct and statements to mean that defendant is asserting his right to cut off questioning, not that a reasonable police officer could understand that. And I think that distinction is really important to this case. Defendant said in the first time, as Judge Tao pointed out, that he didn't want to talk to anybody about anything. And then he continued speaking without the officer or the investigator directing him at all. So whether or not he wanted to talk about anything, he continued to talk. So I think that statement is clearly ambiguous. The second statement, he again, not in direct response to the investigator's question, do you want to talk about this, says, I don't want to talk to anybody about anything. Then he says something that's kind of indiscernible after that. The investigator asks again, basically, as you mentioned, repeats back his statement to him. He confirms, no, I don't want to talk to anybody about anything. And I think that the officer in this case, the whys that was simply a clarification. And the officer under Supreme Court case law wasn't even required to clarify. Where a statement allegedly invoking is ambiguous, an officer need not clarify. But examining the totality of the circumstances, which is the inquiry here, a reasonable police officer would not have known necessarily that defendant wanted to stop talking. And
It seems to me, though, that some of the statements that the defendant made are rather unambiguous. I mean, he says about 3 times, I don't want to say anything about anything. I don't want to talk to anybody about anything. And if he is reflecting to himself after he says that, why wouldn't a reasonable police officer say, you know, this is sort of a critical point in the investigation here. We have the defendant in an interrogation room, and we know that there's such a thing as a Miranda warning. We've given that to him, and he says, I don't want to talk to anybody about anything. You just made your argument, but tell me why it's so critical that he says afterwards, well, wait a minute, was that Sunday? What was I doing on Sunday? How did that make it ambiguous that he didn't want to talk to anybody?
Well, I think that so the inquiry is whether the defendant's words would indicate a desire to end questioning. And I think I disagree that talking to anybody about anything is not ambiguous. I think that also could register displeasure with the environment, with the circumstances. He's just dragged from his house.
In this context, I mean, you think that a reasonable police officer would say, oh, he's talking about, he doesn't want to talk about global warming with anybody. I don't think that's reasonable.
Sure.
I think it's more reasonable that he's saying, I don't want to talk to you guys.
And
I don't
yet,
want to talk to anybody about anything.
Certainly, but he keeps talking, and I think that adds the ambiguity here.
So what does he have to do? He said, does a defendant in this circumstance have to say, I don't want to speak to you as a police officer about this case, period?
So there's
and not say anything else?
Certainly.
Not muse about today's news or anything else?
So there's no talismanic language required here, and defendant doesn't have to speak as an Oxford Don, as the Supreme Court said. But I think that there has to be some indication that this experience, your questions, I don't want to answer them. And the problem is, every time that the investigator said, do you want to talk to me about this, he equivocated. You don't just examine the defendant's words, it's also the investigator's words. And it's the totality of the circumstances, as we've said many times. And so I think understanding all of that, here it just was ambiguous. He wasn't saying, I want this interrogation to cease. And what's important is afterward, after this whole discussion that's sort of set forth on pages 8 and 9 in the answer brief, thereafter, he does ask for an attorney, and that's scrupulously honored. So I think that here, to the extent that there's some suggestion that there's coercion from not listening to him invoke his rights, they were ambiguous and unequivocal to begin with, or they were ambiguous and equivocal to begin with, and then once he did ask for his attorney, that was honored, and the police officers left the room. I do want to talk about the one point that opposing counsel raised about the fact that the officers, when they left the room in the video, one of the investigators says, we'll be back. I don't think that sheds or somehow minimizes the fact that defendant's invocation of his right to counsel here was not honored. I think that defendant asks for counsel. Presumably, counsel has to get back to the room somehow. So I don't think that just the statement from the investigator, we'll be back, or I'll be back, somehow minimizes that request was honored, because the investigators left the room, and they didn't come back until they were summoned, which was about a minute later, according to the video. Like I said, it's a totality of the circumstances analysis, and I think that I looked for cases with similar language here in Colorado, but that Sherrod case, or Sherrod, out of the Seventh Circuit, I think is really helpful, where in that case, the defendant said, I'm not talking about anything, and the Federal Court of Appeals in that case said, that invocation is as much a taunt as an invocation of the right to silence. It's simply ambiguous. A reasonable police officer would not have necessarily known in that case that the questioning must cease. I also think that there are a lot of differences between this case and Bonilla-Barraza, and I'll just highlight the fact that while the defendant in that case continued to speak after saying, no, I don't want to talk, the defendant continued to speak after they had been asked questions by the detective. So I think that's kind of different here, and that sort of plays into the ambiguity here. I wanted to highlight in the Arroyo case, the language that was used there. The defendant in that case said, I don't want to talk no more. And the Supreme Court in that case even said, while they affirmed the trial court suppression order, they noted that reasonable minds could differ about the meaning of that statement. There is some sort of specificity that is required to invoke these important rights. Defendant did so later when he asked for an attorney, but he did not do so earlier when he said, I don't want to talk to anybody about anything. And if there are no other questions about that issue, I'd like to talk about the vagueness claim in this case.
Counsel, before you leave that, do you want to talk about the impact of these first two, I don't want to talk to you, and then the voluntariness of the Miranda warning the third time they spoke to him?
So after the attorney was requested.
Right, when he asked them to come back in.
So because there was no clear, unambiguous, and unequivocal invocation of the right to silence, and because defendant's request for an attorney was scrupulously honored, all the statements made thereafter were admissible.
Assume it was equivocal, or assume it wasn't, assume it was unequivocal.
Sure.
It's a danger of double negatives. Assume that we agree, at least up to the second statement point, that at that point, they should have stopped talking and they didn't. Address the impact downstream from that.
Sure. So in that case, I cited 2 out-of-state cases in the brief. I didn't find anything in Colorado, but those cases applied an attenuation analysis, talking about, okay, well, even if there was this Fifth Amendment violation at the front end, even if the defendant had invoked counsel or silence, I think in those 2 cases it was counsel, but it's still a Fifth Amendment right here. Even in that instance, because the defendant thereafter reinitiated conversation on his own volition, was re-Mirandized and waived the Miranda waiver, and there was nothing to indicate that that waiver was somehow coerced or the product of police misconduct or anything like that, the statements thereafter were admissible. And I think that while I disagree that defendant unambiguously and unequivocally invoked his right to silence, even if this court comes to that conclusion, I think that those 3 facts between the invocation and the statements mean that those are admissible under that sort of attenuation analysis here. And I think those cases are called Height and Adams, and those are factually similar in this regard. Are there any other questions I can answer on the suppression issue? Okay, turning to the vagueness issue, what the defendant is arguing is that the trial court should have, sua sponte, and without any Colorado authority to this effect, concluded that the abuse of corpse statute was unconstitutional, one of the gravest duties imposed upon the courts. As I mentioned in the brief, this doesn't need to be reviewed at all. Doing so does not promote judicial economy or efficiency. But I also wanted to, if this court takes up this claim, I think that plain error review clearly applies. I don't read my opposing counsel's briefs as asserting that structural error somehow applies. And while the Fuentes-Espinoza case did not articulate a standard of reversal, it didn't hold that plain error is inapplicable to this sort of context, that unpreserved constitutional errors are not subject to plain error review. Looking back to Novotny, the Supreme Court firmly held that there's the trial errors and there are structural errors, and that trial errors unpreserved, that's a plain error issue. Under 52, Crim P 52B, I think that this clearly falls into plain error territory if this court reviews this claim.
Why wouldn't it be structural error if someone were convicted under a statute that we ultimately found to be, or would find if we were to reach it, unconstitutionally vague?
So I haven't found any cases that reverse for structural from Colorado post 52B, I suppose, on a vagueness challenge. I just don't think that there's any carve out to Rule 52 that says that. But in this case, it's not vague, so you need not even get there. The abuse of a corpse statute provides a normative standard of conduct. And while it's not mathematically precise, it doesn't have to be. Statutes don't have to be drawn with mathematical precision. And that standard is conduct that would outrage normal family sensibilities. It's similar to a reasonable person standard. It provides some sort of baseline of conduct that would not be unusual to persons of ordinary intelligence.
And in this case, as I understand the allegations, it was that the victim was rolled in a carpet and left in the garage.
Rolled in a carpet, wrapped in a rope, and then put the entire carpet was shoved underneath a car. And I don't read defendant's brief as arguing that it was vague as to him in any way.
But if that's the case, if that's sufficient to be abusive corpse, why would there not be an abusive corpse charge available in every single homicide case? Because in every single homicide case, either the body is abandoned, left on the side of the road, left in a ditch in the weather, not given the quote-unquote Christian burial. What about, and I know it's not an as-applied, but if the argument is we don't know if it's normative, we don't know what it is that will offend those sensibilities. This seems to be nothing, there was no mutilation, there was no act above and beyond just hiding the body. Where does the line get drawn if, in fact, there's a normative behavior line to be drawn?
Well, I think that there was more than hiding the body here. And I think that in some circumstances, how a body was hidden could certainly fall under this statute. And I don't think it would be improper to charge it in that way at all. But not only did defendant wrap up the body in a rug, tie it up, and stick it in the garage and leave it, but pieces of the brain and the upper skeleton were thrown away in the garbage, things of this nature. And so I think that this clearly falls under this normative standard that would be an outrage to normal family sensibilities. I don't necessarily agree that dumping a body on the side of a road would not fall into the abuse of a corpse statute. You know, that's not a normal way to treat or to dispose of someone's dead body. And I think that, you know, the model penal code, the comments talk about how this statute was really drafted to address family members and sort of provide some sort of, I don't know if cure is the way to put it, but I think that family members could certainly be offended by that, and that could outrage normal family sensibilities to drop a body by the side of the road.
What if it drops as an act of being shot and the shooter just leaves it? Is that the same?
I don't, if the person falls down, I don't think that that would fall into the context because there's no treatment in that sense. And that's what, you know, the statute here talks about treating the body in a way that would outrage normal family sensibilities. But if you shot it and then did not touch it, I don't think that's a treatment per se. But throwing the body out of a moving car, I think that you could certainly say that that is treatment. That's some sort of conduct that would outrage normal family sensibilities. In this case, the trial court simply did not plainly err. The statute on its face is not vague because, as I said, it provides a normative standard of conduct. And if there are no further questions that I can answer for the court, the people request affirmance.
Thank you, counsel. Counsel, you have about 57 seconds to rebut.
As to the first issue, I wanted to just briefly address the Arroyo case. The state points out that there the court said reasonable minds could differ, where the defendant said, I don't want to talk no more. But it's key there, again, going back to considering the whole context, that what that statement was in response to was the officer saying, do you want a break? And then in response to that, she said, I don't want to talk no more. And so there, I think reasonable minds could differ because it's in response to this idea about wanting a temporary break, whereas here the officer is asking, do you want to talk to me, generally? And he says, I don't want to talk to anyone about anything. So I think this case is even stronger than the invocation in Arroyo. I was able to look back at my notes, and both of the retribution and vendetta statements do occur after he unambiguously invokes his right to counsel. So again, under the Smith v. Illinois case, this court should not look to subsequent statements to undermine the ambiguity. And then last thing, nope, I see I'm about out of time. I would ask this court to reverse Mr. Greenlow's convictions and vacate the abuse of a corpse conviction. Thank you.
Thank you, counsel. And the court thanks both counsel for your excellent arguments. And those arguments are going to be very helpful to the division in rendering an opinion. So the matter will now stand submitted to the division, and a written opinion will issue in due course. Thank you again, and counsel are excused from this case. People versus Coaron, 2015 CA 1147. Do council have any questions about our policies or procedures or protocol? All right, with that, we're ready to proceed when you are, council.
May it please the court and opposing counsel, my name is Jeff Svela, registration number 51768, and I represent April Coran. I'd like to spend my time this afternoon on issue 1 in the briefing, which concerns the availability of an affirmative self-defense instruction. Self-defense is a factual question for the jury. The trial court here erred in taking that question away from the jury before it heard any evidence before trial on a categorical understanding of the law that our Supreme Court has rejected as recently as Roberts and DeGrate. In reversing, this court should apply the following rule. Where the state charges a specific intent crime, a general intent crime, or a crime involving willfulness, and there's some credible evidence to support a jury finding that the defendant had a reasonable belief that she needed to use force to defend herself and use the amount of force reasonably necessary for that purpose, the defendant gets that instruction.
Aren't you editing out language? Doesn't it have to be force against a person?
Your Honor, I believe I can turn to the plain language now, and the language in the statute, 704.1, is person is justified in using physical force upon another person. But I think the plain language in this case supports Ms. Coran's position for a few reasons. First, that language can't be read in isolation. It needs to be read in conjunction with the rest of the language at subsection 1. And the last clause in that provision is, he may use a degree of force which he reasonably believes to be necessary for that purpose. That language indicates that a defendant has this defense available to her where she uses the least amount of force required to counter the victim's unlawful use of force.
But it still has to be force upon a person, does it not?
Yeah, it has to be force upon another person. But getting to a second point, our Supreme Court in Fuller, in a footnote, made clear that the operative word force here should be understood broadly to give effect, and this court should follow that and give effect to legislative intent here. I mean, this court's basic job in construing statutory language is to give effect to legislative intent and also avoid an absurd result. The legislature could not have intended for Ms. Coran to assault the victim here rather than just damage his car if all that was necessary to counter his unlawful use of force when he grabbed her arm was to just kick his car door.
Wouldn't that be more a choice of evils than a self-defense?
If I understand your question correctly, choice of evils isn't a satisfactory alternative to Ms. Coran's choice of defense here. It's her constitutional right to advance a theory of defense of her choosing. And so even if that defense were available to her, the court still has an obligation to instruct on the defense that she chose. Also, choice of evils doesn't, unlike self-defense, it imposes a duty to retreat. And so it's not an adequate substitute. Also, the case law is so extreme in choice of evils context. Like there's a case that says, it's not in the briefing, I don't believe, but someone's getting attacked in prison and there's notes left for that person saying that they're threatening murder, and the defendant escapes and tries to raise choice of evils as a defense there, and it's not available. So it's a very extreme, rare sort of defense.
Counsel, let me ask you this. Isn't the operative word in the statute, or it appears to me to be the operative word, is upon? And what does upon another person mean? And explain to me how using force against a vehicle can be force upon another person.
Well, Your Honor, the Supreme Court, with respect, has disagreed with you. As recently as this year in Castillo, our Supreme Court said that the touchstone of self-defense is the reasonableness of a defendant's belief. It's a fact question for the jury. If the availability of this defense turned on where the force was ultimately directed, on some kind of categorical understanding of the law, then our Supreme Court's recent decisions in Roberts and DeGrate make no sense whatsoever, because one of those is a property crime. robbery. And then going back to Smith and Fuller, in the cases from the late 80s in this context, where the defendant is charged with criminal mischief and damages property, the court doesn't say this defense is never available to you as a matter of law. It engages with the facts. In DeGrate, right, the facts support the instruction. In Smith and Fuller, they don't, but it's a factual inquiry.
But counsel, you're ignoring the fact that in those cases, the force was clearly applied upon a person, whereas here the force was applied, at least arguably, on the car.
No, that's not true, Your Honor. Smith and Fuller, when Smith, he shoots a car. There's no one around at all. In Fuller, he kicks out a car window. There's no one around at all. So they say that in Smith, right, like Smith is, at first, it's in a house, right? The victim and the defendant are there, and they get into it, and the victim attacks the defendant. The defendant gets a gun, leaves the house where the victim is, and then shoots up his car in an angry response to what he's done. Then comes back in the house, and the conflict restarts. And the Supreme Court engages with those facts before deciding that he couldn't have gotten the defense, because no jury could have found that he reasonably believed he needed to use force to counter that, what the victim did to him inside. And in Fuller,
Wasn't that the basis for the decision?
it's factual, right? It's not
Yes.
legal.
Yeah.
And that's part of the error here, Your Honor, is that the trial court decided before trial, initially the court had it right and said, when defense counsel moved in this case before trial to ask for this instruction, the court punted and said, I don't know, I need to see how the evidence shakes out. But then later on, right before the jury is impaneled, the court goes back and reads Pickering incorrectly to say that this defense is not available as a matter of law, right? If that were true, then DeGrate certainly makes no sense. If you're looking for a categorical answer to this question, DeGrate has no instructive value, but in reality, DeGrate has tremendous instructive value, not only because it makes clear that this is a fact question, but because the facts in DeGrate track the ones presented here very closely. In both cases, we have a defendant and a victim who are arguing about money. They're alone, just the two of them near a car. In both cases, the defendant says, I needed to use force to get away from this person. The cab driver in DeGrate tries to hold this guy back. Here, Mr. Kanai grabbed my client's wrist, preventing her from leaving. The use of force, where it ends up being directed again, is not dispositive. Her decision, once he grabs her arm and she decides it's reasonably necessary to use force, that's what's controlling for purposes of getting this question before a jury.
So you're asking us to essentially edit the words upon a person out of the statute?
No, I'm asking this court to give them consistent effect with how this court has always understood criminal mischief since Fuller and Smith, right? This is a fact question. And also instructive are, because this precise question, we haven't found a case, neither side has found a case where this exact question is resolved. The high courts in Texas and Washington have understood very similar statutory language in the self-defense context to allow for this defense in this sort of situation where property is damaged and mischief. That's Arth and Boget.
And do those statutes include the phrase upon a person?
Yes, or one of them is upon another, and then the language in Arth, I believe, actually includes a disjunctive between another and person, but it's tantamount. And actually, I believe in Boget, a corresponding clause says immediately necessary as opposed to reasonably necessary, which seems to impose, if anything, a higher standard in Texas than it does here. And in both cases, right? I mean, worst case scenario here for my client, the last clause of 7041 creates some ambiguity. It seems to say that the defendant only gets to use the least amount of force necessary to defend herself, and she did that here. It's more force than necessary for him to assault Mr. Kanai to get away from him. So if there's any ambiguity here, the court in Boget, for instance, found some ambiguity and applied the rule of lenity to allow the defendant to present this question to the jury where it belongs.
Is it your position that if an individual is fearful and in need of defending him or herself, and let's assume that it would be reasonable, that they could shoot an animal?
Okay.
Not a horse the person's riding at them, that would be a little bit more clear, but just to distract the person, they shoot his dog. Is that self-defense?
Well, we haven't had a jury decide the question. I'm trying to answer your question by saying it's a question for the jury. If
Is it? You would let that one go to the jury?
What's the charge?
It's probably criminal mischief, I suppose, or cruelty to animals.
Yeah, I mean, I think maybe. You know, if there's some credible evidence to show that the defendant had a reasonable belief that she needed to use force, and that was arguably the kind of force reasonably necessary to counter whatever was going on, then potentially. You know, this area of law with respect doesn't really lend itself to categorical black letter law rules. It's a fact question, like Your Honor's question suggests. So, yeah, if there's no, does that answer your question?
Sort of, but go ahead.
How can I answer it better? I'm sorry.
Well, I think you might be misunderstanding. We might be crossing in the night. My question is not premised on the assumption that a defense is applicable or not applicable based on whether it's a crime against a person or a crime against property. That's not what I'm asking. What I'm asking is, does the force engaged in have to be applied upon a person?
I think yes, but the key word there is upon, and I don't believe that word should be understood in a way that leads to an absurd result. I think that upon is a preposition that could capture a lot. I don't think, maybe the best way to answer your question is, I don't think that a defendant has to physically touch or assault someone in order to raise this defense. Upon connotes a larger meaning than that. And like I said, even assuming this court reads those words in isolation to say that as a matter of law, you don't get a defense here, the last clause in 704.1 seems to contradict that and create some ambiguity there, right? Because at least on this record here, Ms. Coran certainly used the least amount of force required. And when the statute says may use a degree of force which he reasonably believes to be necessary, it doesn't seem to allow her to do more than what's necessary to counter his unlawful use of force.
So if Ms. Coran had kicked the victim rather than the victim's car, you believe that would have been excessive force or more force than reasonably necessary, and she would not have been able to claim self-defense in that case?
Well, I still think it's a jury question, Your Honor. What my point isn't that she wouldn't be allowed the offense if she had assaulted him. My position is that the statutory language is clear and allows for this defense because this is a factual question for the jury. And maybe a way of putting it is in the alternative, assuming this court agrees with the state that upon another person doesn't allow the defense in these circumstances. I don't think that's correct because the last clause of the statute creates some ambiguity there. It's not entirely clear.
So in that case, the prosecution could have argued that, well, she could have used less force. She could have kicked the car instead of kicking the victim.
Exactly, and that would be an absurd result for the defense to rise and fall based on how the state charges conduct. That doesn't make any kind of sense. Right? As the court said in Castillo, it's a question as to the defendant's reasonable belief. The jury needs to at least hear, the judge needs to hear some evidence at trial before deciding whether to make this defense available to her. That's part of the error here, right? Is that it's a fact question and they took it away from the jury. The jury gets to decide these questions, whether her belief was reasonable and the amount of force that they said was reasonable. Going back to how the hypothetical you just posited, Judge Hawthorne, if she had kicked him, right, then it's up to the jury to decide whether that's self-defense because she had a reasonable belief that she needed to do so and that amount of force she used was what was reasonably necessary.
Is it also a fact question for the jury to determine whether the force was used upon a person?
I think the best answer to that question is that this plain language creates a gatekeeping obligation on the trial court. The trial court gets to decide whether this comes in, right? And after Ms. Coran, in this case, after she's testified and said that I kicked the car door in self-defense, then the court can decide whether it's up to the jury to decide. So it's not a easy yes or no question, right? The court gets to decide whether some credible evidence supports it, and then the jury gets fully instructed on the language in 7401.
But what I'm saying is, assuming the trial court had submitted it, is it for the jury to determine whether or not the force that was used can be characterized as being upon a person or not?
Yeah, I think that's the correct understanding of the law, Your Honor. But after the court has heard evidence and allowed the instruction. And if there's no further questions, I'd like to reserve what little time I have left for rebuttal. Thanks.
May it please the court, my name is Jillian Price, registration number 40815, and I represent the people. If Ms. Koharan's conduct was justified, it's because she was acting out of necessity, not out of self-defense, as we understand that affirmative defense in 181704. The General Assembly, in drafting that statute, specifically used the words upon another person when defining self-defense. And the plain language of that statute therefore encompasses force upon a person, not upon property. Now, the people are not unmindful of the concern that the defense raises vis-a-vis using the least amount of force in self-preservation here, attacking a car, and that a defendant, according to the defense, should be penalized by not being allowed to assert affirmative defense of self-defense. However, because self-defense is codified in 181704 with the language that the legislature chose, that is a decision that is best left to the General Assembly. And the existence of the choice of evils defense, which is grounded in common law principles of necessity, substantially mitigates any problem that that might cause.
Counsel, let me ask you a hypothetical. If someone is threatening another person and the threatened person decides they'll shoot at the wall and scare this person away, would they not be entitled to self-defense if they're charged in with the mischief of shooting the wall, if they believed the person was about to attack them?
That would still be a property crime, and I would still assert that that would fall under a choice of evils defense. That is not force upon another person.
But doesn't the defendant get to choose the defense they want?
Not under the way that our statutes are written. Again, 181704 specifically says force upon another person. By contrast, choice of evils is not anywhere near as restrictive and could apply in the situation that you just described. By stating upon another person, the legislature was contemplating some sort of force to the person of what in this case would be the victim. Shooting at a wall as a distractionary tactic and then being charged with criminal mischief would still put that situation under the category of a property crime for which a necessity or choice of evils defense with an adequate foundation might be raised. But absent that force upon another person component, the affirmative defense of self-defense simply does not apply as our statute is written. So
are you making the categorical argument that your opposing counsel argues against, that if it's a property crime, there's no self-defense?
I am. As an alternative argument, though, and as articulated in the briefs, and as Boget, Arth, and DML illustrate, if a defendant, or rather, if a victim is using a piece of property as an extension of his person, and that property is then damaged in the course of a defensive act, that could fall under self-defense because the force used would then still be directed at the person of the victim.
So let me give you a fact pattern. The individual is clearly under attack, and the only method of defense available to that person is a handy baseball bat. They grab the bat, they swing the bat at the individual, knowing that the individual has hidden behind a lamp. The person is charged with both assault for hitting the person with the bat and criminal mischief for damaging the lamp or the vase or whatever it might have been. In your characterization of the categorical defense, self-defense would be available on the assault but not available on the criminal mischief. Is that correct?
Under the under the categorical argument, yes.
Does that make any sense?
Well, the situation that you're describing is actually very similar to DML, which is the Florida case that I believe both of us have cited. In that case, the victim was attacking the defendant with a handy baseball bat. And the defendant held up, I believe, a skateboard as a defensive measure, and in that scuffle, the skateboard ended up hitting and damaging the victim's truck, causing the property damage. Under that unique fact situation, the Florida court determined that that self-defense was appropriate in that case. I still say that a purely property crime should not be eligible for self-defense. In the situation that happened in DML and in the hypothetical that you just described, we also have a component of a physical attack that appears at least to be occurring simultaneously to the property damage. So that is a slightly distinguishable fact situation from what we have here.
And I don't dispute that, but I'm getting specifically at your categorical approach would not care about the fact that the single act of defense against the person doesn't count because it damages property. It accounts toward the assault, but not toward the property crime allegations.
Under a categorical argument, that is correct. And again, that goes back to the statutory language that the General Assembly decided to use in 181704.
But didn't that person didn't the person charged in my hypothetical use force upon a person and in so doing damaged property? So aren't they fully under the statute?
If we are parsing out just criminal mischief from assault, if we're just parsing the property crime from the assault, yes. We have a property crime that does not fall under 18174, and we have a crime involving force upon a person.
What about a person is entitled to use defense or to use force upon a person? What about the language of 181704 limits it to crimes against persons? Crimes against persons is defined as the action of the individual in terms of the criminal act, but force against a person, force upon a person, can occur even in the context of a property crime, can it not?
Perhaps.
I slap a glass out of your hand, I damage the glass. I've still used force upon you, have I not?
If there is a slap, yes, against the hand, then yes, you've caused force upon that person. So perhaps I misspoke saying crimes against persons. I should be focusing more on force upon a person. And for my semantic mistake, I apologize. But if that force is indeed upon the person slapping the glass, that would still be force upon the person. We don't have that in this case. What we have here is, from the defendant's own testimony, she intended to kick the car and only the car. This is a purely property crime with no physical component.
Why did she intend to kick the car according to her testimony?
According to her testimony, let's see, on page 236 of the May 19th transcript, lines 1 through 4, my intent in kicking the door, I guess, was to not only use it as leverage just to pull away from him, but also to distract him to let me go.
So let's talk about that for a minute. Use as leverage.
Mm-hmm.
She plants her foot against his car so that she can wrench her wrist out of his grasp. I assume that's what she means by leverage, or at least it's a reasonable reading of what she meant. Is that not force upon a person?
No, that is force upon the car, not force upon a person.
Even though the act of removing the wrist from the grip or the body from the grip, doesn't it still have some impact on the person?
Well, she has not applied any force upon the person. She has applied force upon the car, according to her testimony, and the facts in this case are disputed. The defendant asserts that he never touched her at all. But taking her testimony, assuming her testimony is accurate, she did not apply any force to the victim at any point in time. This was a purely property situation.
How does she get her wrist out of his grip if she doesn't apply force against that grip?
Well, she kicks the car, and she says she's trying to distract him, sure. But she kicks the car. She does not kick him. She does not apply any force upon him, which is what 181704 requires.
I don't think you're answering Judge Tao's question. Her testimony is, and I'm repeating what Judge Tao just said, but she had He had his hand around her wrist. So she has to apply some force on some portion of his body to rip her wrist away from his hand, right?
I don't know that that's true.
Well, wouldn't that be for the jury to decide? But but my question is, I'm following on what Judge Tao said, isn't that force?
Well,
Force upon a person?
the victim has her wrist.
All right, so they're
Okay.
in contact.
Right, so
Right.
the victim has grabbed her wrist.
Right.
We have no testimony on this record that she did anything but kick the car
And pull
and
out.
pull out.
pull
But that's not force upon the person. She has used
Why not?
force upon the car.
Why not? Why isn't that force? Why isn't that force upon the person?
Well, she is withdrawing from his grip, not
Yes.
applying force upon him. So maybe this is a subtle and fine line distinction, but
I think it would be subtle, because let's say she didn't pull her hand out. Let's say that she twisted her hand in such a way that it twisted the victim's hand. Would that be force?
Or let's switch it. Let's say their bodies were in the opposite position. She reaches backward and launches herself by kicking the car into him to knock him down so that she can get free. Would that
Well-
not be force upon the person?
if she launches herself into him,
Using
then
the
she
car as
has-
leverage.
Well, but using the car as leverage, sure, but she has still then applied force upon him. And that would be indeed similar to your baseball bat and lamp situation, but we would still have a distinct property crime and a distinct application of force upon another person. And there's no factual evidence in this case to show that there was the application of force upon the victim that Your Honors are describing. We simply have the force upon the vehicle. Now, turning additionally to counsel's argument that self-defense should apply in all general intent crimes. As cited in the brief, there are several crimes that fall under the general intent category for which self-defense could never be raised, such as sexual assault, internet exploitation of a child, excuse me, stalking, harassment. To institute a categorical rule that self-defense is always available in those crimes would indeed be an absurd result. There is no self-defense component to internet exploitation of a child. There's no factual situation, there's no legal situation in which that could possibly apply. So as the trial court's gatekeeping function goes, there is a component that the trial court needs to look at what actually happened in this case, and does that fall within the confines of 18-1704. And in this case, the trial court made the correct decision in determining that it did not. Unless this court has any further questions on this or any of the other issues raised in the briefs, the people respectfully request that you affirm. Thank you.
Thank you, counsel. Counsel, you have 16 seconds.
Just very briefly, I think after DeGrate and Taylor, the argument that this can't apply to property crime is out the window because both those were property crimes. And also, just to reiterate and answer your question, Judge Tao, upon another person is a factual question for the jury once the instruction is properly given.
Thank you.
Thank you. And court thanks both counsel for your arguments. Those arguments will be helpful to us in reaching a decision in this case. So the matter will stand submitted to the court, and an opinion will issue in due course. Thank you very much. Counsel are excused. The court will be in recess for today, and the bailiff may so announce. Thank you.
Court will be in recess subject to